Broadcast is now starting. All attendees are in listen-only mode.
Good afternoon and welcome to this edition of the SCR webinar series, Current Issues Affecting Real Estate Professionals, Risk Management. This SCR webinar is proudly sponsored by REF. And with us today we have Mandi Dudgeon, and she's an attorney with Carlock, Copeland Stair, LLP in Charleston, South Carolina, where she handles a wide variety of litigation matters throughout the state. And I'm going to go ahead and turn it over to Mandi.
Thanks, Mike. Again, my name is Mandi Dudgeon. I practice in Charleston. I'm grateful to Mike for setting it up so I could give this webinar from my office rather than driving through the rain to Columbia. But most of my practice involves representing professionals, including realtors. And I just want to go over some of the issues that I've come across in my practice and some of the trends in the industry today. And if you have any questions at the conclusion, I'm happy to try to answer those, or you can always contact me at my office. We're going to go over some of the recent law and the case law in South Carolina affecting realtors, as well as trends in the industry that impact those claims, also some of the specific claims that I see, and then throughout the presentation I'm going to go over some risk management tips that can hopefully help you in your profession. Disclosure duties, that's one of the biggest things that comes up in cases that I see. I'm sure you're probably all aware, but your duties include duties similar to most professions, and they're words that we hear a lot and don't always think about, but it's a duty of loyalty, obedience, disclosure, confidentiality, reasonable care, diligence, and accounting. And all those duties are actually part of the South Carolina Code section that applies to real estate professionals. And the one that comes up most is disclosure. And I'm sure most of you again are aware, but you don't have a duty to inspect or investigate these properties that you are selling or looking for on behalf of a buyer, but you do have a duty once you are aware of something to disclose that. And this becomes an issue especially with the new seller disclosure forms. Obviously since they just went into effect August 1st, we don't know really the impact that they will have, but my advice still remains the same, and that is do not fill out those forms for your clients. Let them do it. And if they have questions about them, either refer them to an attorney, or if the question is specifically, do I need to disclose X? More often than not, that's going to be putting you on notice of an issue, and if you find out about it, you're going to have to disclose it. So let your clients handle that disclosure statement, obviously to make the process smooth for them, but don't interject yourself into an uncomfortable position that could result in problems later. One thing also to note is that when you're representing a buyer, just because something is listed in a disclosure statement doesn't protect that buyer and give them the option of suing the seller in the end. If there's something in a disclosure statement that you or your buyer is aware of as untrue, or has heard there may be an issue with it, you may be on notice, and just because it's in a disclosure statement, that doesn't give you full reign to come back against the seller. Earnest money issues come up a lot, and I'm sure everyone's aware, but whenever there's a dispute regarding earnest money, immediately you need to make sure that before anything is dispersed, you either have a separate agreement signed by all the parties releasing that money, or you can have an interpleader action filed, or a court order can allow you to release it, or you can go through mediation. Those are the four options. Under no other circumstances should you release earnest money that is disputed. UTPA, that's probably a legal term you might not hear very often, but the Unfair Trade Practices Act is something that in the past we have seen really just be against, for instance, car dealerships for lemon law issues or bad practices. It's essentially a statute in place to keep businesses in check and keep professions in check, and to avoid patterns of practice that are against the public interest. And in the past, we've thought that they wouldn't apply against attorneys or against realtors, but recent case law from last year showed that likely an individual could maintain what we call UTPA action against realtors. And one of the reasons that's important is it enables them to get treble damages or triple damages. So it's more than just your typical negligence cause of action. So it's just something to be aware of in what you do. Limitations of liability. This is something kind of on the forefront of the law. In March of 2013, a limitation of liability term was upheld in a home inspector's contract. Now what that means is often there'll be a clause in the contract that says the professional's liability is only limited to some amount. In other words, you may sue me for $50,000 because you're upset that I didn't find this water intrusion issue. I'm speaking as though I were the home inspector. But I'm limited to just my fee in this case, which may have been $300. Our Supreme Court actually upheld and enforced a limitation of liability clause in a home inspector contract recently, and I think it will be interesting to see when it comes to it, because I expect it will, how the limitation of liability term is handled in the new contract. The new sales contract for realtors. I'm interested to see how that's going to play out, but hopefully, for y'all's sake, it will be upheld. I want to go over some of the trends only because they do impact the type of claims that are occurring against realtors. REO properties, obviously with all the foreclosures, there are a lot of properties owned by lenders. And this impacts claims because it just causes complications, not only for realtors, but also for property managers, or we're seeing more property preservation firms. Sometimes realtors are getting into that business. Just you need to be on a heightened level of due diligence when you're dealing with these properties and dealing with the lenders. Tainted real estate transactions, I'm referring to mostly the mortgage fraud, and I think the trend is actually going down for mortgage fraud. The banks have put a lot of things in place to try to avoid it. We don't see as many straw buyers or borrower fraud or flips. The reason this affects realtors is because when something goes wrong, often all of the professionals are named in a lawsuit. They'll name the realtor, the appraiser, the closing attorney. Any professional they can find becomes named. And oftentimes you may have nothing to do with the actual fraud, but you really have to have, you know, a lot of these cases, although they may seem frivolous, are going back to you should have seen these red flags, especially if you're sitting at the closing table and you've never seen the person who's purchasing this property, you know, things like that, just to always be aware. But again, I believe the trend is going down for tainted real estate transactions. Property management, I think that's on the rise due to the foreclosures, the REO properties, and fewer sales. A lot of people are getting into property management, so I think that trend is going up. And then finally, FDCPA, that's the Fair Debt Collections Practices Act. I saw a statistic that those claims are up 14% since 2009. I think they will continue to rise. That can apply also to property managers when they're trying to collect owed debt. You know, the law is that you cannot harass people, and I think my advice is always, you know, if they say they have an attorney, talk to that attorney. Don't continue to contact the person, and do things in writing and do them in a professional manner, and keep your records very straight as to what's owed. I've seen too many times where a property manager who's also trying to sell the property is, you know, contacting the tenants over and over again, and then I find out that their records weren't even correct. They'd already been paid. So just make sure if you're going to be trying to collect a debt in any fashion, you are keeping your records very straight. I want to cover some of the claims that I see and also some ways to avoid them. We've already touched base on misrepresentations and failure to disclose. And again, this takes us back to the disclosure forms. Do not fill them out. Have your clients fill them out, and when they have questions, they should see an attorney, or, you know, not in every instance you need to see an attorney, but if it's something that you're not comfortable answering, they need to see an attorney. And that really shouldn't matter whether you're under the old form or the new form. That advice still applies. Vendors and experts. I do see some claims arising out of, I think they're typically frivolous, but they exist. When you're trying to do your job well, you're trying to make the process very smooth for your clients, smooth for your buyers, smooth for your sellers, and oftentimes you know of several, you know of the best contractor to go to, you know of the best home inspector, the best engineer, and that's fine. You can maintain that network, but give your clients options. Give them options in what experts they want to use, and do not do the due diligence for them. Do not sign a contract with the contractor. Do not handle a home inspection without your client being there. It's very important that while you're making the process smooth for your buyers or even for your sellers, that you are still allowing them to be the buyer or the seller. I've seen cases where, for instance, the realtor is trying to get things done quickly. They're coordinating these inspections. They're signing off on something for a contractor just to get it done because their client's out of town. Well, when that contractor doesn't get paid, they can put a mechanics lien on the property, and that can involve you and come back to hurt you. So just make sure that while you are a facilitator, you're facilitating that process, but you aren't putting yourself into the shoes of your client. Accepting seller reports, this is kind of common sense, but when you get a report from the seller, you hand it off to your buyer. The obvious disclaimer is this came from the seller. We can't necessarily rely on it, but it is the buyer's option to do so or to get their own expert. MLS listings, I see some frivolous claims coming out of misrepresentations in an MLS listing. I think most realtors are very savvy in this area, but utilize disclaimers where you can. Don't make assumptions. And if you're going to put something in your listing regarding a survey or regarding a zoning, make sure you have documentation to back it up, and make sure that your clients are signing off on that listing. Earnest money disputes, we touched on them before, but just the key issue here, they often come up in claims, and the realtor just gets named, even though they shouldn't be named. They're doing the right thing. They're keeping the money. They're holding the money while the parties dispute over it. Just don't release it unless you fall under one of those 4 categories, unless you have an agreement or an interpleader or a court order or mediation. And don't be afraid to contact your insurance carrier when you are named. Don't bury your head in the sand and say, I didn't do anything wrong. I don't care if I'm named in a suit. You still need to contact your carrier and tell them, so an attorney can get involved and get you out of that suit and explain to the parties that you don't need to be a part of this. You're doing your job by holding on to the money, but you're also happy to pay it into the court while they dispute the issue. The claims on this screen I do not see as often, but zoning surveys and permits, again, don't make assumptions or representations about these issues. Even if something's public record that the buyer arguably could find on their own, you can make that argument, but if you know about something that's going to become an issue down the road, it's usually best to disclose it and not to make representations to your clients or to the other side about the existence of certain zoning issues or encroachments become an issue as well when there are no surveys in place. HOA covenants and restrictions, again, I do not see many of these claims, but it's not your job to interpret HOA covenants. They're often not drafted very clearly, but your clients are looking to you to give you advice, and if it's outside the scope of your expertise, just don't do it. They can ask their closing attorney even. They may have to pay a couple $100 more for them to review it, but it's worth it in the long run. I'm also not seeing too many claims arising out of REO properties, but I think that could come, down the way, because there is a 3-year statute of limitations on all lawsuits, and since we have so many REO properties right now, I think those claims could come later. Finally, claims against property managers. Typically, they involve either some allegation about financials, not having enough audits, or they can come through a personal injury claim based on failure to maintain the facility. That can become an issue. Also, again, the FDCPA claims can come up against property managers when they're trying to also act to collect debt. And then obviously, to be aware of the fair housing regulations. This really comes up more in other states like New York. And I think that, we may see some of these claims in South Carolina, but hopefully not many. Collateral issues that come up, and these are just things that you need to be aware of if you're ever named in a lawsuit. and be aware of as you're involved in the risk management to avoid those lawsuits. You're dealing with emotional clients sometimes, even when you have a sophisticated individual. You handle real estate transactions every day, but for some people it's their just not really rational. Keep that in mind. LLR complaints, we see a lot of LLR complaints in conjunction with a lawsuit, and I think the key in that instance is just to be very responsive to the LLR, to, again, put your carrier on notice. Sometimes you have a no deductible assistance to deal with the LLR. Don't bury your head in the sand, especially if you didn't mess up. Just be very professional, and that's something that we have often, and it feels more personal to the realtors, but it's even more reason to be on top of things. And sometimes it's even important than a lawsuit, an LLR complaint. Deductibles, I think it's important for brokers to have a clear agreement with their agents as to how to handle deductibles. When you get an attorney involved in a case, we don't know what your individual agreement is. So, make sure that that's clear, and the carrier and the attorney are going to want that amount to be paid, but you need to know if you're doing it by a percentage or if the agent's responsible for the entire deductible. Just make sure you have that clear and in writing to avoid problems later on. Broker versus agent liability. This can come up when there's a lawsuit against the company and the agent, and there's some dispute about essentially the underlying facts or what happened. Brokers are typically not responsible for any activities by the agent outside the scope of their employment or not in furtherance of the actual company, but they need to be aware of, it's best to be on the same page and, maintain a united front, a united defense if you are both named, but there may be some instances where you will both need an attorney, and just to keep that in mind if you're ever both named in a suit. Also, for fraud or intentional acts, this can become an issue because there's no coverage. So if there's an allegation of fraud, intentional act in the suit, there won't likely be insurance coverage for it, and just not to be alarmed as a broker in that instance, because you may get what's called a reservation of rights letter from your carrier. That's not necessarily a significant issue, but just be aware of it and seek separate counsel to make sure that you have the adequate coverage in place. Some risk management tips, I guess, and we've kind of gone through them throughout the presentation so far, but communicate and document. That seems simple, but it is so important, especially with contracts and extensions. You may have a very good relationship with the realtor on the other side, and you're not as concerned about a deadline going by or getting that extension signed and in writing. Please do that, because just because you have a good working relationship, it doesn't mean that the buyer and seller are going to maintain or share that same rapport. So keep your extensions timely and in writing, and email can be both a blessing and a curse. When you have a significant conversation with your clients, document it with an email. And I don't mean it has to, not necessarily a formal follow-up, but just kind of confirming what you discussed will really help you in the future. I know those two things seem to be simple, but they're very important. And when you come across a dispute, either with your own client or with the other side, I would recommend just hitting it head on. We're problem solvers, but oftentimes you want to avoid things, and just do not do that. Be responsive. Some of my cases really just result out of the realtor not wanting to deal with something and not wanting to respond to their client, and that can become a problem. Clear scope of services. That's definitely important for property managers, because they can involve so many different aspects of how they're handling the property, either from facilities maintenance or the financial aspect. Make sure you have a clear scope of services with the owner, so that you know what you're doing. Agency disclosures. I think most realtors and most of my clients are very good at this, but obviously dual agency is only proper with informed consent and that it's confirmed in writing. I think that most realtors do a good job with this. The seller disclosure forms, again, the new forms are going to create a lot of questions, but I think if you continue to stay informed through this webinar series, I believe there was one on July 25th that went over the new forms. So stay informed, stay in contact with a mentor if you're a new realtor. If you're a more experienced realtor, be willing to help out those who are new to the profession. I think that's important to keep. It benefits the entire profession in the end to do that. Just some risk management for property managers specifically. You know, physically walk the property. We see problems when everything's done remotely or through email with board members. You know, you need to actually be on that property. Be responsive both to owners, tenants, and HOA members, and then be in communication with the owner and the board throughout. And I think that can avoid problems in the future. And then finally, these are just, again, some things are common sense, but it's very important for your profession to be proactive. Do not bury your head in the sand when there's a dispute. Get things accomplished and take care of them. Stick to your profession. Don't try to be the engineer or the contractor or the lawyer. It's not worth it for you in the end. Don't be afraid to find a friend who's an attorney who will answer your questions when you need them, and call them. And then finally, I think this has been kind of a common theme throughout the webinar, but don't do the due diligence for your buyers. You're a facilitator. You can make the process very smooth for them without putting yourself into their position. And that completes the webinar. If anyone has any questions, I am happy to answer them. I went over a lot of law without mentioning the cases, but I do have references and sources if you have any questions about specific law or information or about the new documents. Thank you. And Mike, I'll turn it over to you.
Hey, Mandy, good job. Quick question. Does agency law apply to commercial real estate agents in South Carolina?
The agency law from the common law perspective applies, but not all the statutory issues do.
But for like agency disclosure and some of the license law, does that apply to commercial real estate agents?
I don't believe the forms do but the actual the statutory, which statute in particular?
Kind of like buyer agency, seller agency, dual agency, designated agency. Does that apply to commercial real estate agents?
I haven't seen claims in the commercial context, so I'm not sure. Most of ours have been in the residential context.
And could you give like kind of a brief thumbnail explanation? What happens in your law firm when you get a claim into the law firm? What's kind of the procedures that go on the lawyer side of the house?
Sure, that's a good question. Typically what happens is, from the realtor's perspective, when they get a claim, they contact their carrier. That carrier typically has a relationship with numerous law firms who handle these cases, and they will contact us. So the realtor's first phone call, maybe from the carrier just saying, Mandi Dudgeon has been retained to represent you. And in that case, we represent the realtor. We do not represent the carrier, but the contact does come through that carrier. So the realtor will get a call from me saying, we've been hired to represent you, and the first thing you need to do really is get all your documentation together. I think that's the hardest thing, is getting documents to us, because we can't really analyze what's going on unless you get a document to us. So getting the file to me is usually the first step, and then I'll meet with the client and just kind of discuss what the case is. And the process sometimes takes longer than you want it to, but there's always things going on behind the scenes. And it also depends if you're in some type of a pre-suit matter or actually in suit. If you're pre-suit, we're just really analyzing and trying to avoid a lawsuit and hoping to resolve the dispute beforehand. if you're in suit, we have certain deadlines to follow through the court action, and it typically takes at least a year for an in-suit case to come up for trial. We also recommend, this is kind of an aside, but we also recommend that you utilize mediation or arbitration if you can. That can be very beneficial and avoid the stressors of litigation. But to answer your question, what happens when we get the case in is that the realtor will get a call from us saying, we represent you, we need your documentation, and then depending on your insurance carrier's guidelines, you may pay your deductible to the insurance carrier or you may pay it to the attorney. And then after that, your carrier takes care of the remaining expenses and fees.
I mean, one more, there's a question here. What is a carrier insurance? Should I have one, or is that up to my broker? I think they're asking, can you give a kind of a brief explanation of errors and admissions insurance?
Absolutely. When I'm saying carrier, I'm referring to an errors and omissions insurance carrier. And typically, when your broker, often that's one of the first conversations you should probably have is what are the guidelines for who's carrying the insurance. Yes, the broker will typically carry the E&O insurance, but you need to know what it applies to, whether or not you need a separate policy for things that aren't covered, and that's going to be different for each broker and for each insurance carrier. When I say carrier, I'm referring to errors and omissions coverage, and that's coverage for your negligence, or, we are all professionals, but we do make mistakes and we need insurance for that. What it does not cover an act or fraud. So if you're stealing money, it's not going to cover that, but it will cover you for negligence.
Good job, Mandy. One question from our Gordon C. Is asking, could you give a little bit more detail on some issues you're seeing in short sales? Realtors are doing a lot of short sales around the state. Any issues you're seeing with short sales?
I haven't seen any lawsuit arising out of them, but the questions I've gotten have really just dealt with how do we speed this process up. And, truthfully, I think that, and I'm not just saying it because I'm an attorney, but if you need to find the attorneys who really have a good relationship with the lenders and can be efficient with those short sales. And you, as a realtor, you kind of have to stay out of it once you have an offer. Say you're representing a buyer. You have an offer, you present it, and it's okay to keep, harass people, keep them moving, but when you're advising your buyers, just make sure you don't give them a specific time frame, because you don't know. I mean, these short sales can be quick and take forever. And I think, the complaints that I'm getting are about, well, my realtor told me it was only going to take a couple months, and we're 6 months down the road. So don't set the expectations high, and make sure that you're dealing with a closing attorney who specifically deals in short sales and already has a relationship with the lender, because they know to a T how to get all those I's dotted, T's crossed, and all the right forms submitted to make the processes as efficient as possible.
Good job, Mandy. One quick question. It may be better for them to get it from you later. Do you have a citation for the case on the Unfair Trade Practices Act applied to a real estate transaction handy?
Let's see, I can probably grab it pretty quickly, or I can email it to you, Byron, whichever.
Sure, that'd be fine.
And it was from last year. Here it is. It's 397 SD 391 Hennes versus Shaw, HENNES versus Shaw, and it was the Court of Appeals in 2012, and it didn't specifically find that UTPA was proper, but it essentially implied that it could be used against realtors, and that the exception based on a profession being separately regulated did not apply.
Super. We had a question. This probably comes up with some of your clients. You've got the errors and admissions insurance. There's a claim, and say the insurance company wants to settle, but maybe the broker wants to fight it. What's kind of a brief discussion on that issue?
That does, again, depend on policy. Some policies include what's called a consent clause, and the broker has to actually consent to the settlement within reason. In other words, if the case has got $200,000 in exposure and the settlement's for $2,000, the broker says no, that's not within reason. But some policies do include a consent clause that requires the broker to consent to the actual settlement. In the case where there isn't a consent clause, technically the policy probably allows for the carrier to make the decision, but the broker needs to have that conversation with their attorney. And if it comes to some true dispute or conflict, the broker may need separate individual counsel, but that's usually pretty unusual.
Super. And kind of the realtors that have never gone through a lawsuit, what's kind of the length and time involvement when something goes to trial? What kind of time frame are you used to seeing with the courts now?
Again, from the time a case is filed to the time it comes up on what we call the trial roster is about 1 year in most counties in South Carolina. Sometimes it can take longer if there's a lot of discovery, which is like depositions or a lot of documents involved. But the majority of my cases I'm seeing getting resolved in probably more of the 6 to 9 month time frame if they're not going to trial. It really depends on the case itself, and it's something that can be stressful, but also can be a lot of ups and downs in terms of the attorney may have a lot of contact with you in the beginning, and then things may be quiet until something new happens.
Right. And you touched on property management. This may be outside the scope of the presentation, so just say so. But any comments on, say, like slip and falls, or you're driving a client around in your car and get a car wreck and somebody gets injured, how insurance works with some of those issues for realtors?
Truthfully, I'm not sure without looking at a specific policy. I have seen property managers named in slip and fall lawsuits, and typically I see a reservation of rights from the insurance company, but I don't typically deal with the coverage aspect.
Right.
So I'm not sure that I can answer that in full.
Super. And about how many are you seeing any trends in cases? Are they increasing as the market starts to pick back up, or remaining stable, or what are you seeing at your firm?
Truthfully, the majority of the claims were coming out of, we had, the market was pretty high, 2006 into 2005, 2006. So 3 years from then would have been about 2009. And that 3-year statute of limitations, we saw a lot of claims in 2009 to 2011. I have not seen the increase yet based on the market picking up. I think that will take a while for that to happen.
Great job.
All right, Mandy, it looks like that's all the questions we have. So thank you for tuning in to today's webinar. Stay tuned to your emails. We'll send you out information on upcoming webinars. And thank you and have a great day.
Thank you.